Hey y'all, welcome to TXC Tells All, or welcome back if you're one of our subscribers. So, if you're just hopping in this week, Larita and I are doing lives every day this week. So, Larita started on Saturday, and we're going all the way to Friday with lives every single day. So, we're trying something different. We really like the lives because it gives us a chance to interact with you, discuss things, current events. We talk about legal issues, being attorneys. Me and Larita are both attorneys if you're new to the channel. So we talk about all that stuff, personal finance, everything. So if you haven't checked out our other videos, make sure you go and check those out. We have lives and other content that we do, and we post videos every single week. So hit that subscribe button so you know when we're posting new videos. Even though I don't know about y'all, but have you been getting our notifications? Because a lot of my subscribers have actually been reaching out to us and saying they haven't been getting the notifications when we post new videos. So that's a whole nother story for a different day. We're gonna try to see what's going on with that because I'm not sure why that's happening. Something YouTube's doing, who knows? But anyway, yes, make sure you check out our other videos on the channel. But anyway, getting to what we're talking about today. So I am a civil litigation attorney. So this is why I thought this topic was important to do for our prospective law students, current law students, or attorneys, or people maybe just interested in the legal field. What do civil litigation attorneys really do? What do they really do? Because we see on TV shows all the time. We have the old school stuff, Law and Order. We have Suits. We have Reasonable Doubt, which just recently came out. I started watching that on Hulu. Really good show if you haven't seen it. But anyway, in all of these shows, you see attorneys, you see civil litigation attorneys specifically, and it's glamorized, or obviously TV is not always reality. So let's talk today about what we really do, like truly do. If you were a fly on the wall in my office as a civil litigation attorney on a daily basis, what does that really look like? I wanted to talk about that today too, because our pre-law channel and law student channel is really important to us. We want to, give information to prospective law students, people considering law school, or other attorneys. We want to kind of have content on our channel that reaches that demographic. So that is one of the reasons why I'm doing this video today and doing this live, and hopefully we'll have some other people hop in, some attorneys who subscribe to our channel who can kind of give their idea or their 2 cents on what a civil litigation attorney really does as well. But I think there's a lot of misconceptions, right? So I'm going to start with myth or truth. But before I get to that and give maybe people a few minutes to hop in on this, before I get to that, let me give you a little background about me so you know what I do, and then we can talk. So I graduated law school in 2011, and I've been practicing employment litigation ever since. So that's the only type of law that I've practiced. I do employment discrimination, wrongful termination. I've done overtime, wage and hour issues, but all civil litigation in the employment in the employment arena. So a lot of civil litigators will specialize. That's something that you see a lot with civil litigation. I think I want to say back in the day, but I think before, and some people still do it now where they do practice a multitude of different practice areas. But I'm seeing a trend where more civil litigation attorneys do specialize. They specialize either, let's say, personal injury. They might specialize in family law, specialize in employment, like I do, specialize in corporate law. So most of the people that I know that practice civil litigation do niche down into a particular practice area. For me, I really like employment law. I always have. I interned originally in law school with the American Federation of Government Employees, and that's how I kind of got introduced to employment law through EEO attorneys that worked there that I was interning for. But I like the fact that, I really, really can know the law because I specialize in that area. So when new case law comes out, I read it, I can focus on the different types of discrimination that might apply to my clients. And I just think, honestly, it makes me be a better lawyer because I really have a really good handle on the law that's particular to what I'm practicing and what I need to advocate for my clients. So that's why I like to specialize in employment law. But I do know some people who might specialize in 1, 2 to 3 areas of law, and I don't think there's anything wrong with that. But for me, it's employment law. So that's the background on me. I do employment litigation. I represent mostly plaintiffs, but I also represent defense clients too. In the employment arena, my plaintiffs are usually employees. So usually my clients on the plaintiff side are employees that are experiencing discrimination at work, or they feel like they were wrongfully terminated from their job. And then when I represent the defense side, I'm representing businesses who are trying to defend themselves against a lawsuit brought against them by an employee, or sometimes they're dealing with different employment related business issues. If you think about like human resources type issues, that's usually where it kind of surpasses human resources and moves on to the legal arena. Then I would step in and advocate for the company representing that business. Hey, Judy, AA Legal Focus is in the house. Thanks for joining in and watching the ads first. We appreciate that always. Hopefully, I know Judy is also a attorney and has her own YouTube channel, so check her out. Judy, the YouTube lawyer, but she also does civil litigation. So hopefully she'll hop in later and give her 2 cents on some of the things that I'm talking about. Roxanne, good to see you. Thanks for joining in. Hopefully this information will be helpful to you or at least interesting, but feel free to comment, ask questions, all of that good stuff. It's good to see you. So let's talk about some of the myths. Well, I'm going to say myth or truth, and then we're going to talk about it. All right. So I wrote some stuff down, taking some notes. So if I'm looking over here, don't mind me. So my first myth or truth is civil litigation attorneys are in court all of the time. So we are always in court. Do you think that's a myth or truth? I wish I had the little Jeopardy music playing. I should get that going later. But anyway, so my question was myth or truth, are civil litigation attorneys in court all the time? The answer to that from my personal experience is no. Honestly, if I was to give you kind of a viewpoint of how a case, the trajectory of a civil litigation case, we are not in court most of the time. So let's say a case, I just concluded a case. It went on for about a year and a half. I can tell you I've been to court, physically in court for that case, 0 times. I have never physically stepped foot in court for that case, and it just settled about a month ago after a year and a half of litigation. Now, did I have court hearings? Yes, I definitely had court hearings in federal court, where a lot of my cases are. Since the pandemic, many of our court hearings have been through Zoom. So even though it's October of 2022, a lot of the courts are still doing their hearings through Zoom. And I can say that's especially true in federal court. Now, not saying that some judges don't have you come into court or there aren't jury trials that are happening in person, but as far as like motions and initial conferences with judges and things like that, that's all happening still in federal court, either over the telephone or through Zoom. So we are not, I am not in court a lot at all. And that's not just because of the pandemic, but also just because of how cases are run. A lot of times civil litigation cases, we spend months and months doing discovery, which is, I'll talk a little bit in more detail about that a little later on, but that's mostly just us going back and forth. When I say us, the plaintiff's attorneys and the defense side attorneys going back and forth exchanging information. So that process is called the discovery process, and that's what the bulk of a civil litigation case can be, is discovery. We ask the other side questions and we gather information from them, and they ask us questions and we gather information from our client to provide as part of the discovery. So all the documents and things that you see fly back and forth between the sides in the litigation process, that's not done in court. That's done through email exchanges between counsel. That's done through filings with the court, but not actually physical court appearances like you see on TV, where every 5 minutes the attorneys are running the court and they're like, we're going to argue about this. We're going before the judge tomorrow. In reality, that usually doesn't happen. In fact, most judges require that you write a letter to the court explaining what the problem is, and then they will give you permission, if necessary, to have a hearing with the judge. And a lot of times the judge will just decide on the papers, meaning I submit a letter about my problem, the other side submits a response, the judge looks at that and says, I don't want to see y'all. Here's my decision. So That is the reality. A lot of times we are not in court. So our civil litigation attorneys in court all the time. That is a myth. And especially in my practice with employment discrimination, some other areas of law might have a little bit more frequency that they're in court, but over the course of an employment discrimination civil litigation case, you might be in court maybe 3 times over a year and a half or 2 years. That's not uncommon. So that's one myth. The other one, let's start with number 2, or let's move on to number 2. Memorize your argument or else. So is this a myth or truth that when you are arguing, let's say a motion or something to the judge, that you have to have every detail memorized? So you're not looking at any papers, you're not referring to any notes, you have to have it all up here. Is that a myth or truth? I wish I could sing the Jeopardy song. I don't think I would do a good job, so I'm not gonna do it. I think that's a myth. Now, I will say you definitely want to have the bulk of your argument down in your head cold. You want to have your points and your highlights down in your head. You definitely don't want to be doing any of this where you're like, civil litigation attorneys are in court all the time, memorize your argument. No, that would not be a good look. I've seen some attorneys do it now, but I never think that's a good way to argue because it doesn't convince the judge or the other side that you have a command of your case. So you want to have information in your head to the point that you can articulate it well without looking at your papers. But for me, now different attorneys have different styles. I see Lee's law firm hopped in and said myth. I think he's referring to this that I'm talking about, the having all of your arguments memorized. Roxanne said myth too. So I think y'all are right. I'm with you. But I'm a person that I like to have outlines. So when I go into court to argue a motion, most of the time, I want to have at least my outline and my key facts on a sheet of paper. Even if I just glance at it and refer to it a few times, I like having some information on my papers. One other thing that I've seen, sometimes it might depend on the length of the argument. If you're going to argue a motion for 10 to 15 minutes, you shouldn't really need any notes. You should know what your case law is. You should know your arguments by heart. Not saying that you have to be able to recite every line of the case, but know the highlights. But I have been to oral argument in the appellate court. So Texas appellate court, the 1st or the 14th, or the 5th Circuit, which is the appellate court for this region. And when you're arguing 5th Circuit arguments and briefs and it's been a whole record, you're going to need something. So you usually have your binder with you and you have it tabbed where you can refer, because in appellate court, a lot of times the judges that sit on those panels are going to ask you very, very specific questions, and you may actually need to pull out your case that you have highlighted and refer to an exact line or something like that. So you do not need to have everything memorized, but I will say, depending on what you're arguing and what court you're arguing in, for a civil litigation attorney, it might depend on how much paper you actually want to bring with you to court. So that's that. So let's move on to the next myth or truth. All cases in civil litigation go to trial. Is that myth or truth? I'll give you guys a couple seconds. Do all cases in civil litigation go to trial? That is a myth. Most cases, I can tell you over the last, how long I've been practicing in Houston, since 2013 in Texas, most of your cases, and when I say most, I'm talking since I've been practicing here, I would say about 90% of your cases in civil litigation settle, maybe even a little bit more than that. I see you, Jock and Roxanne, myth. Y'all are both correct, because civil litigation cases nowadays are not going to trial for the most part. They will go through the discovery process, and at the end of the discovery process, the defendants usually file what's called a motion for summary judgment. So that's a motion that essentially tells the court the other side can't meet the elements of their claim, and this case should be decided by the judge before it goes to the jury. That's essentially, I mean, there's some more nuts and bolts, but we won't get into the details of that. But essentially, once that motion is filed, if the judge grants that motion, so meaning grants the motion for summary judgment, the case is over, and the case will never move forward to a jury trial. the only option that the plaintiff would have at that point is to appeal it to the appellate court, appeal that decision. But if the judge denies the motion for summary judgment, that would signal, okay, we're supposed to move forward for a trial, with a trial, a jury trial, or even a bench trial, which means a judge decides and there's no jury. But what happens most of the time, more often than not, is the case settles. At that point, the case settles, even if the defendant who filed that motion wins. Well, that then the case would be over. So that's not true. But if the plaintiff wins, so meaning the motion for summary judgment was denied, it doesn't go to a jury trial. You think it would, but it doesn't. Usually the case settles at that point. And there's a couple different reasons for that. In civil litigation, when a case goes to a jury, you're putting the result of that case completely in the hands of strangers. And that's obviously, how our civil litigation system, or even criminal litigation system, is made to work. But a lot of people in civil litigation are arguing about money. And the goal at the end of a civil litigation case is to get money. Most people don't want to risk going forward with a jury trial and potentially not getting the opportunity to get money for this case that they may have been litigating for a year or 2 years. So most cases are going to settlements. Either the attorneys are working out or negotiating a settlement, or the case is going to what's called mediation, where a third party, usually attorney who does mediations or a retired judge, mediates the case. Basically, that's a meeting between the parties to see what number can we settle this case for. So that's a myth. Most cases are not going to trial. They are settling. Civil litigation cases nowadays are settling before you even get to trial. Is that a good or bad thing? I mean, I think for my clients, a lot of times it is a good thing, because these are people who were terminated from their jobs. They've usually faced a lot of financial hardship, and they need to get some money as a result of what happened to them. So settlement for a lot of my clients is the best result. And not making them go through the stress of a trial usually is the best option. So my next myth or truth, and I've heard many people say this before, paralegals do all the real work. Civil litigation attorneys don't really do anything. Is that a myth or truth? So let me give some background into this, because I think this all really depends on what type of firm you work for, right? So I think paralegals are essential for civil litigation practice. They're really, really important. I've worked with a lot of great paralegals, and they definitely make my job easier, because they are helping you through what I talked about before, the discovery process. They're helping you stay on top of deadlines. They're helping you communicate with clients. They're doing so much. But in smaller firms, which is what my experience is working in small firms, paralegals don't do all the work. It's really a team effort. You need the associates, you need the partners, you need the paralegals, you need the receptionists, the assistants. You need everybody working together, because it's a small firm and there's so many cases. The paralegals couldn't do all the work by themselves. It would be too much, and the lawyers really have to stay on top of their own caseload, because in small firms, there's usually no case manager. There's not, one paralegal might be doing the work for 3 attorneys. So you can't just dump everything on your paralegal, which you shouldn't anyway. But as an associate or an attorney in smaller firms, you definitely need your paralegal, but you can't just have them doing all the work. So I think overall that would be a myth. But it does depend on the size of the firm, because some bigger firms, I mean, I've never personally worked in big law, so I can't speak about what goes on in there from experience, but they might take on a little bit more responsibility in big law, because they just have the capacity to do that. All right, so other myth or truth. The most challenging part about civil litigation is trial. Now, I don't know if I can answer this from a myth or a truth perspective, because I think this might depend on the personality or what any particular attorney does best. I know some attorneys who love trial, and that's what they're good at. They can't wait for trial. But I know other attorneys that their favorite part is the research and writing part of the litigation, all the stuff that happens before trial, the discovery and all of that. My favorite part of civil litigation is not trial. So I would say for me, the most challenging part about civil litigation would be trial, because that's just not my favorite part. I love the research and writing. I love the, finding the needle in the haystack, and the information that I get from the other side to make the best case for my client. That's the part that I like. And that all happens before trial. And then putting on the show at the end, which is, to me, the trial, is probably the most challenging part for me personally. But I do think that it depends on the attorney. So civil litigation, when it does get to trial, I think it can be challenging because everything is on the line. The jury or the judge in a bench trial is going to make a decision, and that's going to be it, right? Unless you appeal and win. So I think the stress of trial is a lot. All right, last myth or truth. You will have to review thousands of pages of documents as a civil litigator. Is that a myth or truth? So if you're an attorney or law student even, or you're just thinking about going to law school and you don't follow litigation_God on Instagram, go follow them, because they have some hilarious memes about just discovery and the civil litigation process and all of that. And it just adds some humor to some of the heartache that we might experience as attorneys. So litigation_God, if you haven't followed them, go follow them, because it's just funny. But in my cases, in a lot of my employment cases, I do have to review thousands of documents as part of the discovery process to make sure that I know what emails were being sent back and forth about my clients, what the reason for termination was. I've found some really, really valuable information for my client and damaging information for the other side by going through thousands of pages of documents one by one by one. So if you don't like to read, civil litigation is probably not for you. I just want to go through some of these comments. Judy said trials also are quite rare in the civil context. Most cases settle at mediation, which is mandatory in our superior court cases and in federal cases. Good point, Judy. Yes. And that's one thing why I have recently started filing in federal court more often, because out here in Texas too, most federal court judges are now requiring mediation or settlement conference. And so I agree with you. Most cases settle at mediation, which is valuable for me and for my clients. So back to reviewing thousands of documents. I mean, every case is not going to have, it depends on how big the case is, right? If I have a client who only worked at the company for 4 months, I might have 500 pages of documents, just because their personnel file isn't that big. There's not that many emails or correspondence. But I've had cases where my client worked at the company for 35 years and we asked for their entire personnel file. So in cases like that, we might get thousands of documents just because of the length of employment and all the correspondence about that employee that exists. And we have to go through it and see if there's anything that's relevant. So you don't like to read civil litigation? No, probably not for you, because there's no way really to get around that reading. So another thing, so those are kind of myths or truths about civil litigation, just to give you guys a little bit of an idea. Another question: what is something a civil litigation attorney will need to do every single day? That would be, in some way, shape, or form, if you're a civil litigation attorney, you're going to be communicating with a client every single day. Now, I won't say you will communicate with every client every single day, because obviously that's impossible. But your client communication is one of the biggest jobs that you have. You have to communicate with your client at the beginning of the case. And I think I've learned that that's really important, because that's when you gather the facts about the case. When a client comes to me and says, Tracy, I've been wrongfully terminated. Here's the story. Here's what happens. It's my job to ask the right questions to make sure that I get the information to build a case for them. So I need to ask the right questions. 9 times out of 10, they've never been through this process before. They don't know what the legal claims are. They don't know what the legal elements are. They just know what happened to them. So communicating with them and making sure I gather information is important. I'll give you an example. So in employment discrimination, we have really pretty tight deadlines on when we need to get certain things filed, right? So we're going to make a certain type of claim. we have a certain amount of time to get that claim filed. Statute of limitations, and that goes for almost all lawsuits, especially in the civil arena, are going to have a statute of limitations. So in employment cases, part of that is the statute of limitations with the Equal Employment Opportunity Commission, and those can be really, really short deadlines in the legal world, at least. So when you get a client, you have to make sure that you say, hey, I need this information and I need it now. I need to know exactly what happened. I need to know who said what. I need to know, what did you say? Who did you say it to? Do you have that in writing? Do you have text messages, emails? Make sure you're not talking about the lawsuit on social media. There's so many conversations that you need to have with your client. So as a civil litigation attorney, you're going to be talking to your client a lot. Lee's Law Firm says, I have a client that calls me every day. I'm sorry. But that's something that can happen to you. Like, that happens. I call it only client syndrome, bless their hearts. But in employment discrimination world, I will tell you, my clients have just been terminated. So they don't have a job a lot of times when they are talking to me, when they initially hire me. They've just been terminated. They might have been working at the same company for 30 years and they just got terminated. They just went to work in the morning and they said, this is your last day, you can leave. So they're like, hey, I need help. I was wrongfully terminated. I was discriminated against. I have clients who were being called the N-word, and they're like, I reported it, and then the next day they terminated me. So they're distraught, and they're like, hey, you're going to help me out of this. I need to know what to do. What should I do next? They want to talk to you. They paid you money. They think that, or they feel they trust you, that you're going to advocate for them. And they're like, hey, calling you every day is not something that they think is not okay, which it's really not. But they're just nervous. Like, a lot of times when people hire an attorney, they've heard different things about attorneys. They might have trust issues, and they're calling you every day just to make sure you're working on their case. Or, hey, I thought of another piece of information. I want to call you and give it to you. So client communication is definitely something that you're going to have to deal with. And to be honest with you, lack of client communication is one of the biggest ways that attorneys get in trouble, that attorneys get grievances filed against them. I think one of the top reasons that attorneys get clients who file grievances against them is because the client said, I reached out to the attorney and I didn't hear from them for weeks. Or I've sent multiple emails and my attorney hasn't responded. I've tried to call them and they never return my calls. Now, that could be because the attorney is overwhelmed, but that's why a lot of people, a lot of attorneys get in trouble for lack of client communication. Judy said it would sort of be okay if you're billing by the hour. Otherwise, I limit it to one call a week. Yeah, family law is in the family law arena, and I think, Judy, you do some family law too. Every time a client calls, they're getting billed. So, and they know that that's something that would be in their retainer agreement that they're well aware of. So that might limit the calls, or if they keep calling, they just know they're getting charged for it. I don't practice family law. In my practice, most of my cases work on a retainer / contingency arrangement. So when my clients call, I'm not billing them for each call. But I agree with you, Judy. Ideally you do want to limit the calls, but I can tell you some stories. That's a topic for another day. But some clients really just don't get it. They feel like, I paid you and you're now my best friend, my counselor, and my attorney, and I need somebody to talk to. So anytime that something comes to my mind, I'm gonna pick up the phone. But that's sometimes when you do rely on your staff. You have your assistant, take the call and give them whatever update is available, or let them know, the attorney's not available, and we'll give you an update as soon as we have one. That's why sometimes, assistants and receptionists are really important, because they can kind of be the gatekeepers. Because obviously, if you're spending too much time on the phone taking calls that are not really important, you can't spend the time that you need to advocating for the client and working on their case. So that is a balance. Last question. What is one of the most important jobs of a civil litigation attorney at the beginning of a case? Now, this might be personal too, and depends on the type of law you're practicing, but in civil litigation, deadlines are really, really important. Those statute of limitations I mentioned to you before, that is important. So one of the top major jobs you have at the beginning of a case is getting dates and deadlines on your calendar. When is that person's statute of limitations run up? when, if they have to respond to a letter or respond to, a demand made in a contract, when is that response due? You want to get your notice of legal representation out to the other side and make sure you're not missing any deadlines, because once that client retains you for a particular legal issue, they're relying on you. They're not going to be calculating the statute of limitations. They're relying on you to do that. So I would say one of the top jobs that an attorney needs to do once a client retains them is to make sure that they know the dates and deadlines of that case and make sure they have those on their calendar correctly. Because not only could you ruin somebody's case, but you could also commit malpractice, which could put your license in jeopardy. And obviously, that's how we make a living, so we don't want to do that. All right, so that kind of gives you a realistic picture of what civil litigation attorneys actually do. I feel like I could talk on this topic for hours because this is actually what I do day in and day out. But I just wanted to get on here and kind of give an idea, and I hope you actually got a clear picture of what it looks like in reality, not what it looks like on TV, because that's not the case. If you have any other questions and comments, make sure you shoot me a question or comment in the comment section below, and I'll be happy to answer those. Thank you all for joining in. Everybody who commented, I appreciate the discussion. And I will see you tomorrow with another live. Take care. Talk to you later.